the latter request, but subsequently approved a request to appoint Ms. Tagwana as the acting COO. It was these events which led the DA to launch the CA application on 11 October 2016, and in which, among other things, the DA asked for Mr. Motsoeneng's appointment as GECA to be set aside and for him to be barred from holding any position at the SABC unless and until the Public Protector's report was set aside on review. Against that background, we have proceeded first to consider some preliminary points raised on behalf of Mr. Motsoeneng. The first is his contention that the CA application was not properly served on him, that there was not sufficient urgency to justify the shortened timetable, and that the case should thus be struck from the roll. Although the DA's slackness in failing to ensure formal service in one of the prescribed ways is to be deprecated, we are satisfied that the CA application came into the possession of Mr. Motsoeneng and his attorney in sufficient time to prepare answering papers and argument. They would have had the papers sooner if Mr. Motsoeneng had followed the simple expedient of authorizing his attorney to accept service of the application, or if his attorney had timeously communicated to the DA's attorneys that they should send him a copy. The interests of justice would not be served by a strict enforcement of the rules in this particular case. Another preliminary matter we consider is Mr. Motsoeneng's contention that the CA application should be stayed pending the outcome of the SABC's Gauteng application to have the Public Protector's report reviewed and set aside, or pending the outcome of Parliament's ad hoc committee's inquiry into the SABC board. We conclude that the stay application should be dismissed. Insofar as the Gauteng application is concerned, nothing decided there will retrospectively render lawful and rational a decision which in September 2016 was unlawful and irrational. It is not even certain that the merits of the review will be reached in the Gauteng application, because there are likely to be preliminary defences which could lead to the dismissal of that application without a consideration of the rights or wrongs of the Public Protector's report. Insofar as the ad hoc committee is concerned, the committee may well traverse factual matters raised in the present litigation, but for the sole purpose of determining whether the National Assembly should recommend to the President that the SABC's board be dissolved. Neither the ad hoc committee nor a new board will have the power to grant the relief which the DA seeks in the CA application. We have also noted widely reported events which have occurred subsequent to argument in the present case, and which suggest that the ad hoc committee's proceedings are not going to be plain sailing, however strong the committee's resolve may be to proceed expeditiously. One also does not know how long it would take for the National Assembly to act on any recommendation made by the ad hoc committee. The fact that board membership has been allowed to dwindle over a period of more than 2 years without intervention by way of replacements does not bode well. We have then turned to a consideration of the merits of the DC application. That's the disciplinary application. The first point we consider is the precise nature of the disciplinary proceedings required by the Public Protector's remedial action. The DA contended that the Public Protector's factual findings against Mr. Motsoeneng had to be taken as established for purposes of the disciplinary proceedings, and that the only function of the disciplinary proceedings was to determine Mr. Motsoeneng's punishment. If the DA were right on this point, it would mean that the December 2015 disciplinary hearing was unlawful, since it involved the merits of the charges. This was the DA's first ground of review in the DC application. We have rejected the DA's contention on this score, finding that both the merits of the charges and an appropriate sanction are proper matters for investigation in the disciplinary proceedings. This is in accordance with the Public Protector's own view, as explained in argument by her counsel. We have thus considered the further grounds of review raised by the DA. One of these is that the first initiator and disciplinary chairperson and the substitute initiator and disciplinary chairperson were appointed by the minister or with improper influence from her. We agree that the first initiator and chairperson were in substance appointed by the minister and that this was not authorized. We cannot find, however, that the minister's unauthorized involvement amounted to improper interference. We cannot on the papers reject the explanation that she was responding in good faith to a request by the board to make the appointments in view of the board's concern that if it had made the appointments, it would be perceived to be biased in favour of Motsoeneng. In the event, the first initiator and chairperson were not involved in the disciplinary proceedings which cleared Mr. Motsoeneng, because the first chairperson, Mr. Makari SC, concluded that the disciplinary proceedings had become academic in the light of Davis J's decision to set aside Mr. Motsoeneng's appointment as COO. As to the appointment of the substitute initiator and disciplinary chairperson, namely Mr. Falani and Mr. Edeling, we cannot reject the Minister's denial that she played no part in their appointment. By the same token, however, the SABC has chosen not to answer the DA's allegation that those appointments were not brought before the board. Unless there was a proper board decision appointing them, they were not validly appointed, and that is what we have found. That is one basis on which Mr. Edeling's disciplinary judgment of 12 December 2015 must be set aside. We have also considered the DA's allegation that the disciplinary proceedings were in any event a charade and not conducted in good faith. We cannot find on the evidence that the SABC, through its board or senior executives, deliberately sabotaged the disciplinary hearing. There is no evidence that Mr. Palani and Mr. Edeling were puppets acting in accordance with the SABC's dictates. The disciplinary hearing may have been a rushed job because Mr. Makari's decision to abort the previous disciplinary hearing had left the new initiator and new chairperson with only a few days to meet the 60-day limit imposed by the court for the finalization of the disciplinary proceedings. That does not detract from the fact, however, that the disciplinary process was wholly inadequate to constitute compliance with the Public Protector's remedial action. Only some of the matters which the Public Protector required to be the subject of disciplinary proceedings were pursued against Mr. Motsoeneng. Mr. Palani had virtually no time to prepare the prosecution. Many witnesses whose evidence would have been relevant were not called. There appears to have been insufficient consultation with those witnesses who were called. Mr. Edeling referred to postpone the hearing at Mr. Palani's request. Mr. Edeling's disciplinary judgment makes no reference to the Public Protector's report. If he was unaware of it, that was a grave deficiency on the part of those who briefed him. If he was aware of it, we think he should have displayed greater appreciation for his role on behalf of the SABC in giving effect to the Public Protector's remedial action. He was not only acting in effect as the SABC in making the disciplinary decision. The Public Protector's remedial action invested the disciplinary process with a special legal and public significance. The 60-day limit laid down in the court order did not justify a process conducted with indecent haste. The court order specifically envisaged that disciplinary proceedings might not be completed within the 60-day period, in which event the chair of the board needed to file an affidavit explaining why that was the case. Mr. Makari's decision to abort the process at a relatively late stage would obviously have been an acceptable explanation for extending the 60-day limit. For this reason also, we find that the disciplinary proceedings must be set aside. It follows that new disciplinary proceedings will have to be brought in accordance with the Public Protector's remedial action. We point out in the judgment that although the disciplinary charges must include at least those matters identified by the Public Protector, the charges do not have to be limited to those matters. Certain events have occurred subsequent to the Public Protector's report, including criticism by the Supreme Court of Appeal concerning Mr. Motsoeneng's candour in his affidavits relating to his attempts to make contact with Ms. Swanepoel, who he claimed would support his version regarding his matric certificate. The board and the initiator should not approach the matter on the basis that they will only do the bare minimum to comply with the remedial action. They must, in good faith, consider whether there are additional matters to which Mr. Motsoeneng must answer. There is general agreement that the new disciplinary proceedings should be open to the public and that the media should be entitled to record and report on them. Although open access will be the default position, our order will allow the disciplinary chairperson the discretion to limit public and media access on the basis of legitimate considerations. There is a practical problem in starting the new disciplinary proceedings, namely that the SABC's board is inquorate and thus unable to appoint the new initiator and chairperson. The Public Protector's remedial action is directed at the board. During argument, and with a view to a practical solution, we invited the legal representatives for the SABC, Mr. Motsoeneng, the Minister and the Public Protector, to take instructions as to whether their clients might agree on an initiator and chairperson whose appointment we could record in our order. We said that if we did not receive agreed names within 1 week, we would assume the parties could not agree on this course of action. This morning, the Court received a letter from the SABC's attorneys stating that the parties have agreed on a new person to chair the disciplinary proceedings. They have not agreed on the initiator. The SABC has proposed one of 3 senior counsel, while the Public Protector has proposed a 4th senior counsel. The suggestion by the SABC's attorneys is that the Court should select the initiator out of the 4 proposed names. Since I've not been able to discuss this new development with my colleague Lachranji J., who concurred in the final draft of this judgment prior to receipt of this morning's letter, the order we originally proposed to make, namely that the new disciplinary proceedings must be started within 2 weeks of the Board becoming quorate, will be subject to any supplementary order we make pursuant to the latest proposals. We have then turned to a consideration of the CA application, dealing first with the legal effect of the order setting aside Mr. Motsoeneng's appointment as COO. It is common cause that this order caused Mr. Motsoeneng to cease to be a director of the SABC, but the DA went further, contending that it also caused him to cease to be an employee altogether. If Mr. Motsoeneng was a permanent employee immediately prior to his invalid appointment as COO, the setting aside of the appointment would not, in our view, terminate his status as an employee. Whether Motsoeneng was indeed a permanent employee immediately before his invalid appointment as COO is by no means clear. His previous position was as General Executive Stakeholder Relations and Provinces, the position subsequently renamed GECA. It appears that his previous contract had a 5-year fixed term. If, like Mr. Motsoeneng's latest contract, his previous contract contained a clause that he had no expectation to the extension or renewal of the contract, he would, but for his invalid appointment as COO, have ceased to be an employee of the SABC at the end of March 2016. However, since this point was not raised by the DA and has not been fully explored, we have felt compelled to assess the CA application on the basis that Mr. Motsoeneng was a permanent employee prior to his appointment as COO. On that basis, the setting aside of his appointment as COO did not terminate his status as an employee. However, we disagree with the SABC's contention that Mr. Motsoeneng, by operation of law, reverted to being the incumbent of the GECA post, required to be redeployed to another general executive post. Furthermore, the SABC did not merely treat Mr. Motsoeneng as resuming a position by operation of law. The SABC concluded a new 5-year contract with him, which will only expire in September 2021. And the SABC did so on the basis that he was entitled to retain his COO remuneration, something we find quite inexplicable. If he was not validly appointed as COO, he cannot now expect to be paid a COO's salary. The decision to appoint Mr. Motsoeneng to the position of GECA was, contrary to the SABC's argument, the exercise of a public power which can, in principle, be scrutinized on review on the basis of the constitutional principle of legality. It is unnecessary to decide whether this exercise of public power also constituted administrative action for purposes of the Promotion of Administrative Justice Act, because if that act were applicable, the time limits for bringing the review application were complied with. We have concluded that the decision to appoint Mr. Motsoeneng to the GECA post was irrational and unlawful for much the same reasons as vitiated his previous appointment as COO. Although the SABC had in the meanwhile launched proceedings in Gauteng to have the Public Protector's report set aside, that application has yet to be decided. In the meanwhile, the Public Protector's findings and remedial action retain the same status as they had when Mr. Motsoeneng was invalidly appointed as COO. Furthermore, subsequent to the Public Protector's report, there have been further events which cast doubt on Mr. Motsoeneng's suitability for appointment. We have rejected the argument that although Mr. Motsoeneng may not, as matters currently stand, be validly appointed as COO, he can nevertheless be appointed to the lesser position of GECA. Although the latter position may be less influential, it is nevertheless a very senior position to which important responsibilities attach. Since we have concluded that Mr. Motsoeneng's appointment as GECA must be set aside, the question arises as to what should be done until the Gauteng application has been determined or the new disciplinary proceedings finalized. We have concluded that Mr. Motsoeneng should not be entitled to hold any position in the SABC unless and until the Public Protector's report is set aside or the new disciplinary proceedings are resolved in his favour. Whether the SABC is obliged to continue paying him during the period of suspension may depend on the unresolved question mentioned earlier about the expiry of Mr. Motsoeneng's previous fixed-term appointment. That is a matter on which the SABC will need to take legal advice. In the CA application, the DA seeks a declaration that the SABC's board became inquirate on 14 September 2016. This relief is uncontentious. It follows that because the board was inquirate, Ms. Togwana's appointment as acting COO was invalid. We will thus set aside her appointment. We reject the request to suspend the setting aside of her appointment. One should not, by way of suspension, mask the true state of affairs, which is that the SABC lacks a board to govern its affairs. The sooner that is resolved, the better. In the meanwhile, the day-to-day work which a COO would ordinarily perform may have to be done by others, but they will not have the status or authority of a COO. We will, however, direct that the invalidity of Ms. Togwana's appointment will not by itself invalidate anything done by her prior to the date of our order. Finally, we have considered the costs of the two applications. Since the SABC did not ultimately oppose the DC application, we think the SABC should pay the DA's costs on an unopposed basis. Although Mr. Motsoeneng opposed the DC application, more recently he and his legal representatives have focused their opposition on the CA application. One of the important points they addressed in the context of the CA application is also relevant to the DC application, namely whether the Public Protector's remedial action contemplated a sanctions-only disciplinary hearing. We have found against the DA on this point. It was important for Mr. Motsoeneng to establish the principle that he may contest the merits of the disciplinary charges. Accordingly, and although the DA has obtained substantial success in the DC application, we do not think Motsoeneng should be ordered to pay the costs thereof. Because only limited relief was sought against the Minister, and because we have declined to grant that relief, there will also be no costs order against the Minister in the DC application. In the CA application, the DA has achieved substantial success. Mr. Motsoeneng opposed the application, and he will thus be one of the parties ordered to pay the DA's costs. The SABC also opposed the application. Ordinarily, this would mean that the SABC should pay the costs. However, the DA contends that the costs should be paid by the individual directors, not effectively by the public. Although personal costs orders of this kind are unusual, we have come to the conclusion that such an order is justified in the present case. However, the only director who, in our view, should be ordered to pay the costs on a personal basis is the acting Group Chief Executive Officer, Mr. Aguma, who was the person responsible for appointing Mr. Motsoeneng as GECA and the person responsible for causing the SABC to oppose the CA application. Although the conduct of Professor Maguve and the other directors does them no credit, they were not responsible for the latest appointment or for the opposition to the application. The Minister opposed the CA application on a limited basis. Since the DA has ultimately succeeded, she must pay the costs occasioned by her opposition. However, we cannot find that she has been guilty of improper conduct justifying an order against her in her personal capacity. In summary, for these reasons, more fully set out in the typed judgment, we make the following orders. In the DC application, case 3104 of 2016. A. It is declared that in the respects identified in paragraphs 192, 193, 194, and 195, Roman 1 and 2 of this judgment, the first and second respondents, the SABC and Board respectively, conducted themselves unlawfully and in breach of sections 181.3 and 182.1c of the Constitution by failing to respect and implement the findings and remedial action of the Public Protector in her report of 14 February 2014 entitled When Governance and Ethics Fail. B. It is declared that the disciplinary proceedings instituted against the fourth respondent, Motsoeneng, on or about 12 October 2015, including the ruling of the sixth respondent on 12 December 2015, which we refer to as the old disciplinary proceedings, are inconsistent with the Constitution and invalid. C. The old disciplinary proceedings are reviewed and set aside. D. The SABC is directed to commence disciplinary proceedings against Mr. Motsoeneng inter alia for his dishonesty relating to the misrepresentation of his qualifications, abuse of power, and improper conduct in the appointments and salary increments of Ms. Sally Motsoeneng, and for his role in the purging of senior staff members, resulting in numerous labour disputes and settlement awards against the SABC. Subject to paragraph F below, the new disciplinary proceedings shall be 1. Commenced by a new initiator through the delivery to Motsoeneng of a letter setting out the disciplinary charges within 2 weeks of his or her appointment, such appointment to be made by the Board within 2 weeks of its becoming quorate. 2. Presided over by a new chairperson who shall be an independent person appointed by the Board. And 3. Completed within 2 months from date of commencement. F. It is recorded that, with a view to enabling the new disciplinary proceedings to commence prior to the Board's becoming quorate, the SABC, Motsoeneng, and the Public Protector have agreed on the identity of a person to chair the disciplinary inquiry and have proposed certain names as the initiator. If the Court appoints the disciplinary chairperson and initiator in accordance with these proposals, a decision on which is deferred due to the temporary unavailability of Lagrange J, and which will thus be dealt with in a supplementary order, the new disciplinary proceedings shall be commenced by the appointed initiator within 2 weeks of the Court's supplementary order and be completed within 2 months of commencement. G. If the new disciplinary proceedings are not completed within the 2-month limit mentioned above, the following directions shall apply. 1. The chairperson of the Board, or in the event of there being no such chairperson, the Group Chief Executive Officer or Acting Group Chief Executive Officer, shall by no later than the date on which the said period expires deliver an affidavit to this Court explaining why the proceedings have not been completed and stating when they are likely to be completed. And 2, the applicant shall be entitled within 5 calendar days of delivery of the affidavit by the chairperson or CEO to deliver an affidavit in response thereto. H. The new disciplinary proceedings shall 1. Be open to the public, and 2. The media shall be entitled to record and report on the proceedings, subject to such reasonable restrictions as the chairperson of the disciplinary hearing may impose, taking into account inter alia the right to freedom of expression, open justice, and the principles of openness, accountability, and responsiveness, fairness to Motsoeneng, and fairness to witnesses. I. The SABC shall pay the applicant's costs on an unopposed basis, including those attendant on the employment of 2 counsel. J. Save as aforesaid, no order as to costs is made. We make the following order in the CA application, case 18107 of 2016. A. In regard to the application brought by the first respondent, Motsoeneng, for the striking out of matter from the founding affidavit, para 9 and the third sentence of para 166 of the founding affidavit are struck out. Save as aforesaid, the striking out application is dismissed. B. Motsoeneng's application to stay the main case is dismissed with costs. C. It is declared that, unless and until the negative findings against Motsoeneng in the Public Protector's report are reviewed and set aside, or unless and until Motsoeneng is exonerated from the said negative findings by way of a valid disciplinary hearing, Motsoeneng may not hold any position at all in the second respondent, the SABC. D. It is declared that the decision of the eighth respondent, Aguma, taken on or about 22 September 2016, to employ Motsoeneng as the SABC's General Executive Corporate Affairs is inconsistent with the Constitution, unlawful and invalid, and the said decision is reviewed and set aside. E. It is declared that the decision of the third respondent, being the remaining members of the board as at September 2016, to appoint the 14th respondent, Tagwana, as the acting Chief Operating Officer is inconsistent with the Constitution, unlawful and invalid, and the said decision is reviewed and set aside. F. Decisions taken and acts performed by Tagwana in her purported capacity as acting COO prior to the date of this order are not invalid merely because of the invalidity of her appointment. G. It is declared that in the respect identified in paragraph 195 Roman 3 of this judgment, the SABC, through Aguma, has violated the constitutional obligation, its constitutional obligation in terms of section 181(3) of the Constitution to assist and protect the public protector and to ensure her dignity and effectiveness. H. It is declared that the board of the SABC has been inquirate since 14 September 2016 and remains inquirate. I. Motsoeneng and Aguma, in his personal capacity, directed jointly and severally to pay the applicant's costs. To the extent that the applicant is unable to recover the said costs from Aguma, the applicant shall be entitled to recover same from the SABC. J. The 17th respondent, the Minister of Communications in her said capacity, is directed to pay the applicant's costs occasioned by her opposition, her liability to any relevant extent being joint and several with that of Motsoeneng and Aguma. K. It is recorded that the applications by the Decolonization Foundation and the Musicians Association of South Africa to be admitted as amici curiae were dismissed on 23 November 2016. The said parties are directed to pay the applicant's costs occasioned by their respective applications to be admitted as amici. L. All costs in this order shall include the costs attendant on the employment of two counsel. May I inquire who represents the SABC in noting the judgment? Yes, Mr. Studty. And the public protector? Yes. I presume none of you have instructions in the main case relating to matters relating to the appointment of the initiator. If I can ask you then to convey to your respective attorneys or co-counsel that although the parties have agreed on the appointment of a new disciplinary chairperson, they have put up different names in regard to the new initiator. If we are going to follow the course of appointing them, we would far prefer to appoint an initiator which is agreed between the parties. We can make a supplementary order on this matter within the next day or two, but we would like the SABC, Mr. Motsoeneng, and the Public Protector's legal teams to revert to us as soon as possible with an agreed name. If they can't agree on a single name as the initiator, then as an alternative, we would like their agreement, if they're willing to give it, that they are content for the court to make a selection out of any of the four names that have currently been put up to us. If we don't get an agreement in one form or the other, I do not think we'll be able to follow the course of ourselves appointing the chairperson and initiator. So if you will convey that to your attorneys. The court will then adjourn.
Nee,